after the war in 2009, the government want to make interventions to resolve many social, legal, and other issues pertaining to the affected people of the North and the East. The government appointed a commission called Lessons Learned and Reconciliation Commission. There were many issues brought before LLRC. One of the main or burning issue of the affected community is the land and property ownership and possession of the people of particularly in the North and the East. At the same time, there was another element is the National Action Plan for Promotion and Protection of Human Rights. In that also recommended to have a very specific intervention or mechanism or alternative provision to address the disputes relating to state land and the privately held properties by the people. So those disputes were much more complex in nature due to the war. The nature of the disputes cannot be resolved through Community Mediation Board. One, due to the capacity of the mediators, and because the land is a very specific issue and also it has very complex dimensions. In order to fill the gap which exists in the Mediation Boards Act, the Mediation Special Categories of Disputes Act number 21 of 2003 was enacted by the Parliament. Special Categories of Disputes Act has very specific provisions to establish mediation boards for any issues or problems relating to social or economic issues.
එතකොට ඒ අර්ථයෙන් ගත්තම ඇත්තටම ඉඩම් ආරවුල් කියන්නේ සමාජීය ප්‍රශ්නයක් බවට පත් වෙනවා. ඒකට හේතුව තමයි දැන් ඉඩම කියලා කියන්නේ බොහොම මේ මිනිස්සුන්ට වටින දෙයක්. ඉඩම් වෙනුවෙන් ඕනම සම්බන්ධතාවයක් අත්හරින්න අපේ සමාජයේ මිනිස්සු සූදානම්. මොකද ඒ තරම් ඉඩම කියන එක වටිනවා.
விசேட மத்திய சபைகளில் உள்ள விசேட அம்சம் என்னன்னு சொன்னால் இதில் நியமிக்கப்பட்ட அந்த உறுப்பினர்கள் வந்து விசேட கல்வி தகமையை உடையவங்க. அதே மாதிரி காணி தொடர்பான விசேட அறிவு அவங்களுக்கு இருக்குது.
ඒකට දැන් මේ ඉඩම් සමත මණ්ඩලයට පත් කරන සමතකරුවන්ට සමතකරණය පිළිබඳ පුහුණුවට අමතරව ඉඩම් විෂය පිළිබඳ එහෙම නැත්නම් ඉඩම් නීතිය පිළිබඳ විශේෂ පුහුණුවකුත් ලබා දෙනවා.
The Isha Foundation supported the design of the training program for the land mediation boards, and that has been updated through the SEDR project also on an advanced training module supported by the project.
ඉඩම් සමත මණ්ඩලයේ තියෙනවා මේ විද්වත් කමිටුවක්, එක්ස්පර්ට් පැනල් එකක්. ඒ එක්ස්පර්ට් පැනල් එකේ නීතිඥවරයෙක්, මිනින්දෝරුවරයෙක්, ඊට පස්සේ රජයේ ඉඩම් පිළිබඳ බලතල තියෙන නිලධාරියෙක්, ඒ වගේ අයගෙන් සැදුම්ලත් විද්වත් කමිටුවක් ඉන්නවා මේ හැම ඉඩම් සමත මණ්ඩලයකම. එතකොට දැන් පාර්ශවයන්ට තමන්ගේ ආරවුල පිළිබඳව ඒ විද්වත් කමිටුවෙන් යම් නිර්දේශයක් ලබා ගැනීමට අවශ්‍ය නම් අන්න ඒකට අවස්ථාවක් මේ ඉඩම් සමත මණ්ඩල ඇති කරලා තියෙන ක්‍රමවේදය තුල තියෙනවා.
The land mediation boards were established in the North and the East, and in Anuradhapura as pilot programs. So then I think there was a huge demand by the other district level officers that it has to be expanded to Sri Lanka for all districts.
உண்மையில் அந்த காணி பிணக்குன்னு சொல்கிறது உறவு சார்ந்த விஷயம். இப்போ கட்டாயம் அவங்க தேவைகள் இருக்கும், அதாவது உறவுகளை மேம்படுத்தணும், அத்தோடு பிரச்சனையை தீர்த்து கொள்ளணும்.
දැන් මේ සම්බන්ධතාවය කියන එක සමාජයක පැවැත්මට හරි අවශ්‍ය දෙයක්.
உரிமைகள் சார்ந்த விடயமாக பார்க்கும் பொழுது சட்ட ரீதியாக நம்ம முடிவுகளை தான் எடுக்கணும். ஆனால் இப்போ எல்லை பிரச்சனைகள், அடுத்தது உரித்து தொடர்பான பிரச்சனை வரும்பொழுது அவங்க தேவை சார்பான ஒரு சந்தர்ப்பமாக வருது. அப்போ அந்த டைமில் உரிமை சந்தர்ப்பமாக முடிவெடுத்தால் வெற்றி தோல்விங்கிற முடிவு வரும். ஆனால் இங்கே அப்படி தேவைகள் குறித்த முடிவெடுக்கும் பொழுது அவங்களுக்கு உறவும் மேம்படும், பிரச்சனையும் தீரும்.
සමතකරණයේදී එක්කෙනෙක් දිනන්නේ නැහැ. එක්කෙනෙක් විතරක් දිනන්නේ නැහැ. සමතකරණය කියලා කියන්නේ දෙපාර්ශවයේම දිනන ක්‍රියාවලියක්.
இப்போ ஒரு காணி பிணக்கு பிரச்சனை எடுத்துக்கொண்டால், இப்போ நாங்கள் மாவட்ட நீதிமன்றத்துக்கு போனால் அங்கே அது குறித்து பல வருஷங்கள், கிட்டத்தட்ட சில பிணக்குகள் 45-50 வருஷம் கூட எடுத்துருக்கு, இன்னும் முடிவு ஒன்று வரல. இப்போ அப்படிப்பட்ட ஒரு நிலைமையில் இந்த காணி மத்திய சபைகள் உருவாக்கப்பட்டதில் 60 நாட்களுக்குள்ளே ஏதோ ஒரு முடிவு எடுக்கக்கூடிய வாய்ப்பு இருக்குது. அடுத்து அதை வருகை தந்து கலந்துரையாடலும் இலகுவாக இருக்குது. அதுக்குன்னு உருவாக்கப்பட்டது தான் மத்திய சபை. அதோடு அதில் பயிற்றப்பட்ட நல்ல திறமையான தகுதி வாய்ந்து, அதாவது கல்வி தகமையிலேருந்து எல்லாமே அவங்களுக்கு இருக்குது, அனுபவம் இருக்குது. அதோட அந்த 3 அந்த நிபுணர் குழு ஒரு நான் ஏற்கனவே சொன்னது போல் ஒரு லாயர் இருக்கிறாரு, அடுத்தது ஒரு நில அளவையாளர், அடுத்தது அரச காணிகள் தொடர்பாக கையாளக்கூடிய ஒரு அதிகாரி ஒருத்தர். இப்போ இவங்க எடுக்கிற முடிவு சாதாரண சட்டத்துக்கு அமைய செயற்படுத்த முடியுமாங்கிறது அவங்க தீர்மானிப்பாங்க. ஆனால் அதனால அவங்களுக்கு மற்ற நீதிமன்றத்தில் போயிட்டு ஒரு வழக்கு தாக்கல் செய்து எடுக்கிற முடிவை விட குறைஞ்ச காலத்துக்குள்ளே தங்களுக்குன்னு ஏதோ ஒரு முடிவை எடுக்கக்கூடிய வாய்ப்பு இதனால் கிடைச்சிருக்கு. இந்த 2 தரப்பும் விரும்பினா உடனடியாக தீர்த்து கொள்ளக்கூடிய சந்தர்ப்பம் இருக்குது.
දැන් උපරිම අපි සමත මණ්ඩලයකට යොමු වෙන ආරවුලක් සඳහා මාස 3ක් තුල ඒ සියලු කටයුතු සම්පූර්ණ කරන්න සමත මණ්ඩලයේ උපරිම ප්‍රයත්න දරනවා. එතකොට එවැනි ආරවුලක් සාකච්ඡා කිරීම සඳහා 3 දෙනෙක්ගෙන් සමන්විත මණ්ඩලයකට යොමු කරොත් ඒ යොමු කරපු දිනේ ඉඳන් දින 60ක් ඇතුළත, මම මේ කියන්නේ ඉඩම් සමත මණ්ඩලය සම්බන්ධයෙන් යොමු කරපු දිනේ ඉඳන් දින 60ක් ඇතුළත කටයුතු අවසන් කළ යුතුයි කියන එක පනතේම සඳහන් වෙනවා. ඊළඟට පාර්ශවයන්ට මුදල් වියදම් වීමක් මේක තුල සිද්ධ වෙන්නේ නැහැ. මොකද සමත මණ්ඩලයට ආරවුලක් යොමු කරන්න රුපියල් 5ක වගේ ගාස්තුවක් තමයි පාර්ශවයට වැය වෙන්නේ. ඉතින් ඒ ඇරෙන්න කිසිදු මුදල් අය කිරීමක් සමත මණ්ඩලය හරහා සිද්ධ වෙන්නේ නැහැ. ඉතින් ඊට අමතරව මම කියන්නේ දැන් ඉඩම් සමත මණ්ඩලය කියලා කියන්නේ ඒ විෂයටම ප්‍රවීණත්වයක් සහිත සමතකරුවන් ඉන්න තැන. ඒ නිසා ඒකේ වාසියත් පාර්ශවයන්ට ලැබෙනවා.
So the beauty of mediation is that when there's a settlement, it's what the disputing parties agree to. The mediated settlement is like a contract in general law. So the mediator just facilitates the agreement. But in land mediation, there has to be a step that follows the settlement. So if you need to have a legal document, a new deed or a partition, then that legal provisions fall in, but the agreement itself doesn't have to be enforced. So if it's breached, you can go to court saying this contract has been breached. There is no special regulation or certainly not a judgment that comes from a mediated settlement. It has the validity of a contract in general law. land mediation boards, just as much as community mediation boards also do that, are very conscious about inclusion of diversity. Like any other dispute, land disputes are also very much connected to the people and to their communities. So, I mean, it goes without saying that communities are diverse. Men, women, different ethnic groups, all kinds of differences are there. And land ownership and usage are governed sometimes by different laws as well. For minority communities, there are different laws. So when there's a dispute resolution process for land, it's very important that the people who are in the process are diverse, so that the disputants feel comfortable. And also when you look at diversity, we always highlight ethnicity, religion, men and women. But there are other diversities. Are people with disabilities included enough? Are the regional differences, the town, the village differences? So all that is very important because it's a mechanism by people for people.
Since the land disputes especially are very complex, and at the same time there are so many laws and so many procedural aspects are in place. So for a meaningful resolution, then there should be a very rigorous intervention. At the same time, the follow-up measures need to be taken in order to resolve the disputes in a sustained manner. At the same time, the Ministry of Justice or the Mediation Boards Commission also need to provide the necessary guidance, because the mediation is not a knowledge-based program, it is a skill-based program. So there should be program to enhance the skill and the capacities of mediators constantly, so which will make the mediation program a success.